There were several amendments to the Civil Rights Act of 1964. The first one was in 1972. The Equal Employment Opportunity Act was extended to government employees. In 1978, the Pregnancy Discrimination Act extended the coverage, or at least interpreted the coverage for women who were pregnant. So part of civil rights legislation is it's illegal to discriminate against women because if they are the only ones that can get pregnant. Of course, now we understand with issues of being people who are transgender and someone who may be a trans man may still be able to have a baby. So it's a little bit more complex, but it is still a form of discrimination because if you're able to have a child, that shouldn't inhibit you from being able to still advance and be successful in your company. And that the company can't fire you simply because you're pregnant. And they need to make sure you've got appropriate coverage, for pregnancy in your in compensation and benefits laws. The last major amendment that was done to the Civil Rights Act was in 1991, where it allowed for jury trials, which before that time did not allow. It allowed for what we call compensatory damages, so that someone who, as we've already talked about, someone who is being paid for the pain and suffering that they experienced, and then punitive damages, which punitive damages, again, as you remember, are about the punishment for the employer if they've had repeated problems with this particular issue. It also allowed for extraterritorial application, specifically to U.S. employers abroad. So even if you're abroad, let's say you're running a company in Switzerland, you're still required to adhere to U.S. employment law, even for an organization that's working in a different country. Title VII has been covered, since 1964, and the changes in the interpretations have evolved. And of course, there are different trends that happen as we think about the way Title VII is applied. And so we'll go through some of those specific issues. Again, trends really have an impact on the kinds of cases that we see and the way that we interpret those cases. So early on, as you can see in the first bullet point, a lot of the emphasis was on hiring related issues, where I would hire or not hire somebody because of their because they were a member of a particular class of employees. Nowadays, we're starting to see more issues around compensation related issues and promotion related issues. All that is an important part of that. Harassment law developed as a subset of disparate treatment. And, are we creating a hostile working environment? And what are we doing regarding sexual harassment of people in the workplace? Now, by and large, women are mostly and more likely to be the victims of harassment, and specifically sexual harassment. But that's not entirely the case. That women can harass women, men can harass women, women can harass men, men can harass men. And so we have issues, as we'll get into the chapter on harassment and sexual harassment, that there are subsets of that specifically that we should be aware of. We know over time that religious claims have gotten much more lengthy and more prevalent because after 9/11, a lot of Muslims were experiencing workplace discrimination, sort of guilt by association, because Muslims were the ones that destroyed the World Trade Center towers by flying the planes into them, that they assumed that all Muslims would agree with that, which of course is not the case. But religious workplace activism started to grow, where people want to be able to express themselves religiously, and perhaps when religion is at odds with other groups that are protected, that creates a challenge. For example, religious groups that don't want to honor LGBT employees, whereas Title VII does protect gay and lesbian, bi, transgender, intersex, and everybody else, in that umbrella category. And so they are covered under the law, but then you've got this tension between religious workers who have a certain set of beliefs and a certain set of rules that they are expected to adhere to, be a part of their religion, and that is balanced against what Title VII talks about in terms of some of those challenges. So it is important that we recognize that religious workplace activism is a big issue right now. Retaliation claims are on the rise, where someone submits a charge and then the company is found to be guilty of discrimination, and then there's retaliation for people who are submitting claims against the company. So we're seeing more and more retaliation charges, which are really, really difficult. As I've already said, sex discrimination is now interpreted to include both people with issues around gender identity and transgender folks, as well as people who are on the spectrum of sexual orientation. And so, which is wonderful, right? So now not only do we have federal law protections, but in many states there's state level protections, but the federal level protections are important there to acknowledge. And that was a long, hard battle for many, many years to get sex discrimination to be included as part of transgender and sexual orientation discrimination, have that include transgender and sexual orientation discrimination. What we're also seeing now is more awareness of diversity, equity, and inclusion related issues. And part of it is obviously based on the law, but also sort of where we are in the world, and where we are recognizing that diversity matters, making sure we treat people equitably and fairly, and to be more inclusive. And inclusive isn't just like, oh, I have 3 Black employees, so I'm inclusive. It's more complex than that, right? When we're talking about inclusivity, it's not just having a seat at the table, but it's having your voice heard and having it respected and being sought after. So it isn't just to put cheeks in the seats, as we'd like to say, and having somebody be sitting at the table and serving on a committee, but having them have an influence on the process. That's true inclusivity. Lastly, it's a catalyst to broaden common law at-will exceptions generally. So Title VII has influenced the way we think about at-will employment. We talked about some of those exceptions, right? And we cannot get rid of somebody under pretext that, oh, well, it's at will, but really you were discriminating against them because of their sex, their race, their color, their religion, or their national origin. This is just an excerpt from EEOC charges from 2018. And again, because of the timing when this textbook is researched and oftentimes when citations are included, you're not going to see citations from 2020, many from 2020 or 2021. You're going to see a lot from 2018 and 2019. Just so you're aware of that as you start to read through this material, because the law changes rapidly, but the textbook has to go to publish at a certain period of time. So you can see that retaliation charges represent 51% or almost 52% of all charges filed with the EEOC. 32% are based on gender, 32% based on disability, 32% race, and 22% on age. And that seems weird to see those numbers, but there might be some overlap, right? Someone who's disabled in Black, disabled in, color, whatever. So there may be some overlap here. Color was 4%, national origin 9%, religion 3.7%, almost 4%. Equal Pay Act, we'll deal with issues of pay and compensation. That's 1.4%, and based on genetic information, which is a sort of a new protection that we need to be aware of, and that's not quite 1% yet, but as it says there, percentages add up to more than 100, largely because some of those charges allege multiple bases. So I might be gender and retaliation, gender and disability, gender and race and disability, so there can be some overlaps, and so people are loading all the things in where they might see that. And so retaliation standalone, right? Just because someone is files charges of gender discrimination or disability discrimination, if they're being retaliated against for filing those charges, you have a different set of charges, as you remember from our last chapter, a different set of charges based on retaliation. So you can have discrimination charges and retaliation charges. So Title VII is structured in the following way. We cannot discriminate based on the issues of race, color, gender, and specifically gender. We're talking about sexual orientation, pregnancy, sexual harassment, and gender identity. We also include religion, and it also includes national origin. And all of that is in relationship to hiring, firing, training, disciplining, compensating people, benefits that we offer to people, and how we classify them as, exempt or non-exempt, or whether they're in an area where they're going to get promoted or an area where they're not going to get promoted. And we'll talk about that in terms of adverse impact, or whatever other issues or concerns are regarding terms or conditions of employment. And so it is important that we pay attention to the categories and pay attention to EEO, not just as we hire people, but fundamentally in every employment related decision that we make, we need to be considering issues around Title VII and discrimination. Who has to comply with the federal level Title VII protections? Private employers with 15 or more employees must make sure that they are engaging in equal employment opportunity and following Title VII precautions. Unions must do the same. Joint labor and management committees making admission, referral, training, and other decisions. So these are in unionized environments. We are required to make sure that we are any decisions that we make in these joint committees and in unionized environments, that any of those decisions are made are taking into account discrimination-related issues. Employment agencies and other similar hiring entities that are making referrals for employment, not only are they obligated to make sure that they are not discriminating against these categories of individuals, but if we are bringing on a temporary employee, as we've talked about previously, temporary employees are covered under Title VII. So as we were thinking about who is an employer and who is not an employer, right? And some of those things that we talked about in the very first chapter, this is where we start to see it's important to differentiate if somebody is an independent contractor where they're not protected by Title VII, but if they're a temporary worker or other type of contingent worker, perhaps like an intern, they would be protected under Title VII. So we have to be very careful about the determination of who is an employer and who is not. And that joint employment relationship we have with the temporary agency requires us both to protect those employees from discrimination. And then, of course, federal, state, and local governments also must comply with Title VII. One of the last issues we should be aware of is that employees covered by Title VII include undocumented workers. So if someone is not eligible to work here in the United States, yet they may be working for your company, if they experience discrimination, the EEOC does not ask them their status as a legal alien or eligible to work here in the United States. They will look at the case and they will determine whether or not this undocumented worker has been discriminated against. It is illegal to discriminate against undocumented workers. They may not be eligible for certain forms of relief or like reinstatement or back pay, because if it's found out that they're undocumented, of course, they're going to lose their job. But here's the challenge of this, right? This is a sort of a moral or ethical issue, right? If we've got some competing laws here, like we've got undocumented workers who are going to be afraid to speak up because they don't want to lose their job. And you balance this against a law that says that it will protect you, but that doesn't necessarily mean if you get fired, you're going to get your job back because you're an undocumented worker and there's only so much, that can be done. So this is butting up against INS rules, and that's the Immigration and Naturalization. And so it is challenging, right, to think about how do we ensure that our undocumented workers are protected, but at the same time recognizing that they're undocumented, and this can create challenges for us, legally with immigration laws. There are some employees not covered by Title VII, unfortunately. Any employer that has fewer than 15 employees, if they are engaged in interstate commerce but don't employ at least 15 or more people for 20 or more calendar years in the previous year, or current or previous year, they are not obligated to follow Title VII precautions. Now, just because you don't have to do it doesn't mean you couldn't do it or shouldn't make sure that you're treating people fairly and equitably, because you might have 14 employees right now, but next year you're going to have 17 and you're going to have to implement that as a law anyway. So it is always good practice, and I certainly think about this when I'm engaged in consulting with people. It's always good practice to make sure that you are treating people fairly as best as you can and hiring the best employee, making sure you're giving everybody equal opportunity. It's just that if you're less than 15, you're not obligated to follow some of the discrimination rules and procedures. But again, if you're making good practice and making sure that you are protecting your employees and engaging in good practices, this will be really helpful. Non-U.S. citizens employed outside of the United States are not covered. So if you're an American company and you're employing non-U.S. citizens, they're not covered under Title VII. U.S. citizens employed elsewhere, not for an American company, and if the local law forbids such compliance, like if someone's working in Saudi Arabia, you can't claim sex discrimination because they don't want women in the workplace there, at least in the same way that we have them in the United States. So these are important. It's important to understand who's not covered by Title VII. There are additional employees not covered by Title VII. Employees of religious institutions, associations, or corporations hired to perform work connected with carrying on religious activities. So, for example, I am the president of the board of my church, and our church is not obligated to follow Title VII. Now, mind you, we don't have enough employees to even consider, even if we were obligated to do it, we only have, we actually have only a small handful, 2 or 3 people that we hire and work for us permanently. So we would not be obligated to protect people under the guidelines of Title VII. And the quintessential case here is Petrushka versus Gannon University, and you can read about that in your textbook. Members of communist organizations are not obligated to carry out Title VII. Native Americans also living in or around Native American reservations in the United States, in their particular, where their territories are, they are not obligated to follow Title VII. And a gentle reminder, as we already said, that independent contractors are not employees, and therefore they would not be included in your employee count, nor are you obligated to treat them with the same care that you would an employee regarding Title VII and discrimination.